And welcome back to Square Off. Last week, we told you about the possibility that Arizona could make history by becoming the 38th and final state needed to ratify the Equal Rights Amendment. We heard from Democratic State Rep Pamela Powers-Hanley. She introduced the ERA bill in the House. Today, we're joined by Cathi Herrod, president of the Center for Arizona Policy, one of the most powerful people at the Capitol, and she is urging a no vote on the Equal Rights Amendment. Welcome back to Square Off.
Thanks, Bram.
Let's tell folks first exactly what the Equal Rights Amendment says. There is it on our screen. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So Congress passed the ERA in the early 70s. It needs one more state to ratify it, and Congress still would need to do something to put this back in play because the window for it closed a while ago, which I would expect you'll point out. So the floor is yours. Make the case for the no vote and no filibustering, please.
Sure. Three simple reasons. First, equal rights is already guaranteed. Discrimination on the basis of sex is already illegal in our country and in our state. The second is that, as you pointed out, the ratification deadline passed in 1982. This is a useless exercise because in 1982, the U.S. Supreme Court actually ruled that any challenges to the Equal Rights Amendment were moot. So even if the state were to ratify it, the courts are not going to uphold it as being a valid ratification. And the third reason is that it likely would be interpreted as enshrining abortion rights in the U.S. Constitution.
Okay, so Senator Lisa Murkowski last week said she wants to move a bill that would allow the Equal Rights Amendment basically to come back to life and for Congress to for it to be ratified. So it doesn't seem like it's quite dead yet.
Well, when you have a ratification deadline of 1982, you don't just automatically say, oh, anything that's happened since then is valid. And I think it certainly would be a court decision, but Congress can't go, oh, all of a sudden we meant that 1982 deadline, it's okay in 2019 or 2020. There's no precedent for that.
And my question last week to Pamela Powers-Hanley kind of mirrored what you just said, that the law has moved ahead in many, many ways toward equality, yet advocates for the ERA say women are not fully protected, and in particular the issue of pay. They're definitely not protected because of the disparities.
Well, equal pay is already required by the law, and the University of Arizona lawsuit by female professors demonstrates this. University of Arizona professors have sued the university for unlawful wage discrimination, denying tenure under the Equal Pay Act, under Title VII. So we have the Equal Pay Act, we have Title VII, we have an Arizona wage law. These laws already prohibit discrimination on the basis of sex. So equal pay is already required. What gets lost in the discussion is that men and women make different decisions still on what their work is going to be. 88% of men work full-time, 75% of women work full-time. Different decisions are made as far as the professions entered, taking time out from the workplace. So the difference is when someone says women get a certain percentage of the dollar that a man gets, there are reasons for that. And when you factor in these variables, equal pay, women are getting equal pay. When it's the same job, same conditions, women, and if they're not, they should be filing a lawsuit like the University of Arizona professors did.
And that's what they have been doing. They have been filing lawsuits, and I think certainly at the executive level, high levels that show, there are studies that show they do not get equal pay, and even at levels below that. I'm just surprised to hear that you see pay as being the same.
Well, the Independent Women's Forum has done an excellent job of documenting how that when you throw in the variables for the different choices that are made by men and women, that equal pay is a false narrative. It's not there.
Now, in a release you issued a couple weeks ago, you cited much more than you've done here today as your objections. Among them, women might be subject to the draft. Other things that might lead to more equality of the sexes. You may have brought up same-sex issues in that. What are those objections?
Well, here's one example. Take a domestic violence shelter where you have vulnerable women who are receiving services, they're receiving care, they've been abused, and so the domestic violence shelter only wants to hire women. Well, if you can't discriminate on the basis of sex, then that domestic violence shelter could be forced to hire men. And then vulnerable women in those situations, often they need women caring for them, not men. On the issue of abortion, when you say that you can't discriminate on the basis of sex, you put it in the Constitution, then it could likely be interpreted as saying that abortion restrictions, or you can't do any regulation or restrictions on abortion.
Yet nothing stopped the New York from advancing what you object to, a recent abortion law there. Nothing stops the courts right now from rejecting some of the abortion laws you advance here in Arizona.
Well, let me point out 2 states, Connecticut and New Mexico, have overturned abortion restrictions because of state constitutional equal rights amendments. And as recently as last month, Pennsylvania had Planned Parenthood file a lawsuit on an abortion funding issue under their state ERA, saying that it was unconstitutional. So courts have interpreted state ERAs as enshrining abortion in their state constitutions.
You're also opposing a new anti-discrimination bill at the Capitol, correct?
Yes.
And that's been a consistent stand of yours, standing for expansion of religious rights while at the same time opposing rights for LGBT citizens. And in this case, some might say full and equal rights for women. Why do you take that position?
Well, the proposed law that you're talking about is a solution in search of a problem at this point in time. Our Arizona Supreme Court, for example, has under consideration a case called Brush and Nib that will give some guidance and direction on how you address some of these issues. The business owners, the private business owners who are they're serving all people, but they're not expressing all messages, and that's our concern. That those who have a belief about marriage as being only the union of one man and one woman, is the government going to compel them to use their creative free speech, their free religious rights to create messages that go against their beliefs. And so that's the nub of the issue that we're concerned about.
And that issue really is all about carving out an exemption from discrimination laws for religious faith, religious belief.
No, those laws are about, it's disagreement, not discrimination. And all of these wedding vendors, whether it's the florist, the cake baker, the calligrapher, they are serving all people. They're just saying that they're not going to create all messages. And our First Amendment protects those individuals from being forced to create all messages in violation of their beliefs. And the same government that can force them to create against their beliefs can force anyone to have to violate their beliefs in some other circumstance.
Constitution also talks about freedom from religion.
Well, it talks about being able to freely exercise your religious beliefs. It does not say freedom from religion.
Well, freedom from establishment. Why do you oppose civil rights for LGBT residents, citizens?
This isn't about civil rights. This is about those who disagree about a core issue. It's not discrimination, and it's about enabling those to be able to create freely and pursue their First Amendment rights.
But you did originally oppose the Phoenix Ordinance in 2013, that this is challenging.
Because of this reason. Because it would, civil rights laws are intended to be a shield against discrimination. However, the Phoenix Ordinance, as an example, could be used as a sword to go after people and who want to freely express and create their messages. And for example, the Phoenix Ordinance is one of the few ones that would enact criminal penalties and a jail sentence and a fine for, say, the calligrapher who declined to use her expressive talents to create a message on same-sex marriage.
One last thing on the politics of the ERA. At the Capitol, State Senator freshman Tyler Pace flip-flopped last week on his co-sponsorship of the ERA. He says he no longer co-sponsors it. What do you know about that? Were you involved?
Well, certainly part of our advocacy at the legislature is that we put out, if you've seen our fact sheet, you've seen our information, that we inform legislators of our concerns about legislation, but you'd have to ask Senator Pace as far as why he changed his opinion.
Did you talk to Tyler Pace?
We talked to a lot of legislators about a lot of issues.
Cathi Herrod, thanks very much for joining us.
Thank you.
When we come back, Kelly Ward wins an election, but will the new leader of the Arizona Republican Party help or hurt candidates in the 2020 vote? Stay with us.